Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of banking and finance, contract and family laws. To know more about them, please watch the video fully. Hi friends, the important judgment which is titled GT Grish versus Y Subaraju by legal representatives and another and pronounced on 18th January 2022 deals with that subordinate legislation in the form of statutory rules is a law under section 23 of the Indian Contract Act. The facts of the case would be that the plaintiff instituted the suit in question seeking specific performance. The trial court did not decree the suit for specific performance but directed the return of the amount paid by the plaintiff under the contract. On appeal, the High Court directed the appellants, who are defendants in the suit in question, to execute the sale deed relating to the plain scheduled property in favor of the plaintiffs. The senior counsel, appearing on behalf of the second defendant, argued that the agreement is unlawful, being opposed to public policy, and also as it was a bargain which would defeat the provisions of the law in question within the meaning of section 23 of the Indian Contract Act 1872. The senior counsel for the plaintiff submitted that neither the lease cum sale agreement nor the Bangalore Rules of Allotment 1972 prohibited the allottee entering into an agreement to sell the site. Even Rule 18 of the Bangalore Rules of Allotment 1972 relied upon by the appellants did not stand in the way of the agreement to sell or the sale in favor of the plaintiff. The questions that are posed for consideration is whether the enforcement of the agreement to sell dated 17/11/1982 expressly or impliedly lead to palpably defeat the law in question which is contained in the statutory rules or is prohibited by the same, and whether the agreement in question falls foul of section 23 of the Indian Contract Act. The Supreme Court has held that Rule 18 of the Bangalore Rules of Allotment 1972 speaks about restrictions, conditions and limitations on sale of sites. The provisions also state that for a period of 10 years, the allottee, who is also described as the lessee and purchaser, cannot alienate the site or the building. A contract may expressly or impliedly be prohibited by provisions of the law. The law for the purpose of section 23 of the Indian Contract Act would be law made by the legislature. Regulations or orders made under the authority derived from the legislature referred to by this court are species of subordinate legislation. Statutory rules would also therefore clearly be law. The facts on record would show that the allotment to the first defendant was made on 4/4/1979. In fact, the first defendant was obliged to construct a residential building within 2 years under Rule 17(6) of the Bangalore Rules of Allotment 1972. No doubt the time could be extended thereunder, but at the time the agreement dated 17/11/1982 was entered into, the first defendant was already in breach. The agreement to sell involved clearly terms which are impliedly prohibited by law, in that the first defendant was thereunder to deliver title to the site and prevented from acting upon the clear obligation under law. This is a clear case at any rate wherein enforcing the agreement unambiguously results in defeating the dictate of the law. It would, in allowing the agreement to fructify even at the end of 10-year period of non-alienation, be a case of an agreement which completely defeats the law. It is quite clear that the parties contemplated a state of affairs which is completely inconsistent with and in clear collision with the mandate of the law. It is quite clear that the plaintiff relied upon the illegal transaction in filing the suit for specific performance. On a conspectus of the scheme of the rules, the contract was unenforceable for reason that it clearly, both expressly and impliedly, would defeat the object of the rules, which are statutory in nature. The contract was patently illegal for reasons indicated. A sale of a site to any other person clearly stood prohibited, and unless the allotee or lessee is compelled to sell in the circumstances mentioned in Rule 18.3, the law permitted the sale of the site only to the authority itself. Therefore, if the plaintiff wanted to enforce the agreement for the sale of the site on an immediate basis, it would clearly attract the embargo that it was completely prohibited. The agreement relied upon by the plaintiff cannot be acted upon. In such circumstances, even if we do not reverse the finding of the High Court that the second defendant is not a bona fide purchaser, it will not itself advance the case of the plaintiff. This is for the reason that his case is in the teeth of the law, making it an unenforceable contract. The contract is considered to be an option and brazen instance of parties entering into a bargain with scant regard for the law. If that were not enough, the very first letter addressed to the first defendant betrays the real purpose of the contract. The plaintiff, in no uncertain terms, has declared his intention to sell the property to his nominee. It is clear as daylight that the plaintiff had no intention whatsoever to make use of the site for the purpose of putting up a residential building. Facts on record would show that the bargain was to buy a precious public land which was vested with the Bangalore Development Authority by acquiring it from some person with laudable object of housing a homeless person in Bangalore. The result of the agreement being enforced would be to clearly frustrate the object of the law and make the site the subject matter of a property deal with the object of making a profit. The High Court has clearly erred in holding that the suit was maintainable. The suit to enforce the agreement dated 17/11/1982 should not be countenanced by the court. Coming to the next important judgment, titled VASUDHA, Sethi and others versus KIRAN v. Bhaskar and another, and pronounced on 12th January 2022. In this judgment, the Supreme Court deals with that the rights of the parents are irrelevant when a court decides the issue of custody of their minor child. The facts of the case would be that the unfortunate dispute arose between the appellant number 1, the wife, and the respondent number 1, the husband, over the custody of their minor male child. The father of the child filed a writ of habeas corpus with a prayer for a direction to secure the release of the minor child from the illegal custody of the mother and her parents. The mother was directed to return to USA along with the minor child on or before 30th September 2021. Challenging this order, the mother approached the Supreme Court with allegation that the mother, as the primary caregiver, must be kept in mind as a person who has the legal rights which must be respected and protected, and she cannot be compelled to go back to USA. The issues posed for consideration are whether the High Court was justified in passing an order directing the appellant number 1 to return to USA along with the minor child on or before a particular date, and whether the issue of custody of a minor in a petition seeking habeas corpus or in a custody petition has to be decided on the touchstone of the principle that the welfare of a minor is of paramount consideration. The Supreme Court has held that Section 13(1) of the Hindu Minority and Guardianship Act 1956 provides that in appointment or declaration of guardian of a minor, the welfare of the minor shall be the paramount consideration. When a court decides that it is in the best interest of the minor to remain in the custody of one of the parents, the rights of the other parent are bound to be affected. As provided in Class A of Section 6 of the 1956 Act, in the case of a minor boy or girl, the natural guardian is the father, but ordinarily the custody of a minor who has not completed the age of 5 years shall be with the mother. on a conjoined reading of subsection 1 of section 13 read with class A of section 6 of the 1956 Act, if it is found that the welfare of a minor whose age is more than 5 years requires that his custody should be with the mother, the court is bound to do so. In the same way, if interest of the minor, which is the paramount consideration, requires that the custody of a minor child should not be with the mother, the court will be justified in disturbing the custody of the mother even if the age of the minor is less than 5 years. In such cases, the rights of the father or the mother, as the case may be, conferred by class A of section 6 are bound to be affected. Whenever the court disturbs the custody of one parent, unless there are compelling reasons, the court will normally provide for visitation rights to the other parent. The reason is that the child needs the company of both the parents. The orders for visitation rights are essentially passed for the welfare of minors and for the protection of their right of having the company of both parents. The material on record would show that the High Court has considered all relevant factors while holding a summary inquiry. The High Court has given reasons for coming to the conclusion that it will be in the interest and welfare of the child to return to USA. The High Court has not treated the order of a USA court as conclusive. The High Court had the benefit of the assistance of a learned counsel who was appointed as amicus. The exercise of power by the High Court cannot be said to be perverse or illegal. The emphasis of the learned counsel appearing for the appellants was more on the rights of the appellant number 1 and on making a departure from the well-known concept that the welfare of the minor is the paramount consideration. The said submissions are contrary to the law laid down. Therefore, the rights of the parents are irrelevant when a court decides the custody issue. Further, a writ court, while dealing with the issue of habeas corpus, cannot direct a parent to leave India and to go abroad with the child. If such orders are passed against the wishes of a parent, it will offend her or his rights to privacy. A parent has to be given an option to go abroad with a child. It ultimately depends on the parent concerned to decide and opt for giving a company to the minor child for the sake of the welfare of the child. In this case, on a conjoined reading of class 1 to 3 of paragraph 55 of the impugned judgment, it is apparent that such an option has been given to the appellant number 1. Accordingly, the directions are issued. Now we are going to deal with the important judgment titled Phonics ARC Private Limited versus Vishwa, Bharati, Vidya, Mandir and others, and pronounced on 12th January 2022. In this judgment, the Supreme Court holds that a writ petition challenging proceedings under SURFASI Act initiated by private banks or asset reconstruction companies is not maintainable. The facts of the case would be that respondents, the running educational institutions, avail credit facilities. As the respondents failed and neglected to repay the outstanding dues, the bank issued a notice under Section 13(2) of the SURFASI Act. The NPA account of the respondents with respect to the credit facilities availed by them was assigned by the bank in favor of the appellant. Pursuant to the assignment of the NPA account in favor of the appellant, the respondents approached the appellant with a request for restructuring the repayment of outstanding dues. A letter of acceptance was executed between the parties. Since the borrowers again committed defaults in payment of the outstanding dues, the appellant issued a letter intimating that it would be proceeding to take possession of the mortgage properties after expiry of 15 days from the date of the said letter. Against the aforesaid letter, the respondents filed the writ petitions before the High Court, which passed and extended the interim orders. Feeling aggrieved and dissatisfied with the aforesaid interim orders and extension of the interim orders and entertaining the writ petitions, the appellant preferred the present appeals with allegation that the writ petitions against the communication in question, proposing to take further action under Section 13(4) of the SURFASI Act, and that too against a private assets reconstruction company, shall not be maintainable. The question posed for consideration is whether the High Court is justified in entertaining the writ petitions against the communication in question and to pass the ex parte and interim order virtually stalling or restricting the proceedings under SURFASI Act by the creditor. The Supreme Court has held that filing of writ petitions by the borrowers before the High Court under Article 226 of the Constitution of India is an abuse of process of the court. The writ petitions have been filed against the proposed action to be taken under Section 13(4) of SURFASI Act. Even assuming that the communication in question was a notice under Section 13(4) of the SURFASI Act, in that case also, in view of the statutory efficacious remedy available by way of appeal under Section 17 of the SURFASI Act, the High Court ought not to have entertained the writ petitions. Even the impugned orders passed by the High Court directing to maintain the status quo with respect to the possession of the secured properties on payment of rupees 1 crore only is absolutely unjustifiable. The dues are to the extent of approximately rupees 117 crores. The ad interim relief has been continued since 2015 and the secured creditor is deprived of proceeding further with the action under the SURFASI Act. Filing of the writ petition by the borrowers before the High Court is nothing but an abuse of process of court. It appears that the High Court has initially granted an ex parte ad interim order mechanically and without assigning any reasons. The High Court ought to have appreciated that by passing such an interim order, the rights of the secured creditor to recover the amount due and payable have been seriously prejudiced. The secured creditor and or its assigner have a right to recover the amount due and payable to it from the borrowers. The stay granted by the High Court would have serious adverse impact on the financial health of the secured creditor or assigner. Therefore, the High Court should have been extremely careful and circumspect in exercising its discretion while granting stay in such matters. In these circumstances, the proceedings before the High Court deserve to be dismissed.